Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast, the N.J. Laws 2, looking at recent cases of the New Jersey Supreme Court and Appellate Division. And in this edition, we're looking at some of the cases that were discussed at the seminar handling drug DWI and serious motor vehicle violations, sponsored by the New Jersey Institute for Continuing Legal Education. Now, let's say that there's an arrest warrant and the police stop and arrest someone, but it turns out that the arrest warrant was a mistake because the person had paid their fine. The warrant should not have been issued. Is that grounds for to suppress drugs and guns found? And the answer, according to the United States Supreme Court, is no. In Herring versus United States, the court held that the arrest and search by police based on an invalid warrant does not suppress drugs and a gun found. Herring versus United States, 129, Supreme Court, 695, 2009. Now again, looking at DWI cases, let's see, State versus Chun said inspections of the machine should take place every 6 months, not 1 year. If there was a pre-Chun case in which the inspections were not done within 6 months, is the failure to inspect within 6 months a defense to the Alcotest reading? And the answer is no, under State versus Pollock by the Appellate Division. In Pollock, the Appellate Division said the 6-month Alcotest inspection does not apply until after Chun was decided on March 17, 2008. In Pollock, the defendant appealed his conviction for a per se violation of N.J.S.A 39:4-50, driving with a blood alcohol concentration of 0.08 or more. The court was called upon to determine whether the semi-annual-recalibration requirement for Alcotest machines established by the Supreme Court in State v. Chun is applicable to cases in which the test was administered prior to Chun and in compliance with the then existing annual 1-year calibration protocol. Because the Appellate Division determined that the change mandated by Chun was not intended to be applied previously, so the court affirmed the conviction. That was State versus Pollock, 407 N.J. Super 100, Appellate Division 2009. Let's see. In the Chun case, the Supreme Court held that the driver must be observed for 20 minutes. Let's see. Well, what does 20 minutes mean? And in the first reported case dealing with 20 minutes, a law division judge held that in an Alcotest, the state must prove the defendant was observed for 20 minutes prior to the test. In State versus Filson, Filson, a law division judge held before DWI Alcotest results may be admitted to evidence, the state must prove by clear and convincing evidence that the defendant was observed for 20 minutes before taking the test. Eye-to-eye monitoring is not necessary or really required, even if the defendant is observed by sound and smell. Yet, if the observer leaves the room during the 20 minutes, the observation must begin anew. What suffices observation must be determined in view of the observation requirements, the purpose to assure that the suspect has not ingested or regurgitated substance that would confound the test results. And that's State versus Filson, 409 N.J. Super, 246 Law Division 2009. Prior to determination by Chun, there was a lengthy fact findings by Judge Michael Patrick King, the retired judge that was called upon to be the special master. And the question is, can the defendant use the special master report as a defense at DWI or to vacate a guilty plea? Well, not in Camden County, State versus Coppola. And in that case, the law division held that the special master's report was not adopted completely, and it was only adopted as modified within the Chun opinion, and the Chun opinion found the Alcotest reliable. The law division held that Chun wholly did not adopt King's report in toto, and as such, a per se violation remains a per se violation. That was State versus Pollock, decided by the Law Division in 2009 in Camden County. And one of my favorite cases, can a DWI be charged on private property? Yes. Let's see. And what about a refusal? Let's see. Well, refusal has to be on quasi-public property. Let's see. So, what about a high-rise condo parking lot? Let's see. Yes, a refusal can be charged. State versus Bertrand, BERTRAND, 408 N.J. Super 584. In that case, the appellate division held defendant's conviction for refusing to provide breath samples in violation of N.J.S.A 30-50.2 is affirmed. The parking garage of a high-rise condominium that held 354 cars and the use to which the building was restricted to residents of that building constitute a quasi-public area for the purpose of the statute. And that's State versus Bertrand, 408 N.J. Super 584, Appellate Division 2009. For additional information, contact the law office of Kenneth Verkaman at 732-572-0500. More information on the web at www.njlaws.com. That's NJLAWS.com, and benotguilty.com. That's benotguilty.com. We're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. Future editions, we will look at other cases that affect the drivers and citizens under the Supreme Court and Appellate Division. Thank you.